Well, good afternoon, Michiganders. It is Tuesday, August 23rd, 2022. And this, of course, is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan. And we don't send you a bill. As always, I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome, welcome, welcome to today's program, August 23rd. Can you believe it? Nearing September. I know we still have a lot of good weather ahead of us, but even after all these years, end of August, it just kind of feels like it's time to be going back to school, time for summer to be ending. And it's just, I guess that's just what we grew up with, even though I'm not going back to school. And I know there's plenty of good weather to still be enjoying before we get later in the season. Well, last week's episode, I gave you an audio tour of our virtual office. If you listen to that tour, if you haven't, I encourage you to listen to it. I kind of gave you some outline, if you will, of how it is that we are currently assisting clients virtually. That's through Zoom calls, telephone calls, emails, mail, etc. And it's how we are able to provide assistance to clients pretty much wherever they happen to be in this great state of Michigan. So if you're considering having estate planning work done for you, perhaps need assistance in settling an estate, and you're wondering how can we do that virtually, I encourage you to listen to last week's episode. Today's show, older Americans may be better off staying unmarried. Let me say that again. Older Americans may be better off staying unmarried. But please remember, what I'm about to discuss during the program is, as always, for educational purposes only. It's not intended to be legal advice, and it's not necessarily intended to dissuade you from getting remarried if you are an older American who's considering it. But as always, you should work with your attorney to determine what is best and appropriate for you and your estate plan. Well, today's topic comes from my review of a recent law review article from Washington University Law School, Professor Kaplan at the University of Washington University Law School. And this article just came out in August. And what Professor Kaplan was doing was going through a number of scenarios talking about how the law, be it tax law, be it Medicaid, be it Social Security, different issues that Professor Kaplan looked at, how it seems to favor non-marriage in later years. There's probably all familiar. There are some perhaps tremendous, aside from being in love with our spouses, tremendous tax advantages early on when we looked at the difference, for example, in income tax rates for married people as opposed to single people. Well, Professor Kaplan goes through and notes in a number of situations, though, where actually those laws don't favor marriage for older people. And I know this is something that I've talked to clients about before when they've looked at getting remarried in their 70s and 80s, and they've asked me for my legal advice. And again, I'm never one to discourage people from being in love and getting married, but there are a number of important considerations tax-wise, Social Security, income tax-wise, perhaps Medicaid-wise, and others that you should at least be aware of and give consideration to. And I think as a result of that, what Professor Kaplan was finding today is the vast number of older Americans who are opting to simply live together and cohabitate rather than getting remarried. And on a personal note, when my father, after my mom had passed away and we had conversations about whether or not he would consider getting remarried, I know I had some of these very conversations with him about some of the tax considerations that can dissuade you from getting remarried. So I just want to talk about two of them today very briefly. And I think what I will do is I might even post a link to Professor Kaplan's article. I mean, it's a legal article, it's a long article, but if you're interested in wading through it, you might get some better sense of a number of things that Professor Kaplan is talking about. So I want to talk about, though, two things in particular. And first, let's talk a little bit about Social Security benefits, in particular the income tax aspect of Social Security benefits. I'm not talking about what benefit that you're going to receive, how that's going to be impacted by getting remarried, etc. But let's just give some brief overview of the income tax considerations of Social Security. And as you perhaps know, if you're already drawing Social Security, Uncle Sam started taxing Social Security benefits back in 1983. And it set some various thresholds, and there's two in particular: a minimum threshold at which some benefits might be being taxed at a 50% tax rate, and another threshold at which benefits would be taxed at an 85% tax rate. And noting, too, that unlike many other aspects of federal estate tax law, they are not indexed for inflation. So these numbers, these thresholds have continued to be. So what are they? Well, the first threshold, and you need to think about it when you're looking at getting remarried, is the initial threshold is $25,000 for a single person and $32,000 for a couple. And what is that threshold? Well, essentially, that threshold means if you're a single person and you don't make more than $25,000 as that number is calculated by the IRS, including your Social Security benefit, you don't pay any federal estate tax on those benefits. So $25,000 single person. If you make more than that as a single person, then it's going to depend upon what portion of that earnings is Social Security, but essentially you might be looking at a 50%, not a 50% tax, but a tax on 50% of your Social Security benefit. Now, that same threshold for that minimum threshold is $32,000 for a married couple. So think about that. $25,000 for a single person, $32,000 for a married couple. So let's say you and your significant other are consider getting married, and each of you has $25,000 or just under $25,000 in this income scenario. Well, as two single people, you would not be paying any income tax on Social Security benefits because each of you would have a $25,000 threshold. If you get married, though, now you have a joint income. Let's say it was rounded off at $24,000. Now you have a joint income of $48,000, which means you now are exceeding the $32,000 for a married couple, meaning to the extent that that 48 is Social Security benefits, exceeding the $32,000 threshold, you have a potential of paying income tax now on 50% of the difference between that 32 and the 48, or $16,000, that you have a potential of paying on 50% of that. So if you just look at it what does that mean? If you had stayed unmarried, neither of you would be paying any income tax on that $48,000. But by getting married, you're now putting yourself in a position where you're going to be paying income tax on that same $48,000. So it's pretty clear from that there is a disincentive under that tax structure to consider getting married. Now, the next threshold is $34,000 for a single person and $44,000 for a couple. And that is at $34,000 for a single person. If you exceed that, now you're going to pay tax on 85% of your Social Security income, whereas that married couple is going to pay tax at $44,000. They're going to now pay tax at 85%, not at 85% tax. So same scenario though. Let's say you're higher income individuals, and let's say you each have $33,000 in income. Well, as single people, staying single, each having $33,000 of income, okay, you would still only be paying based upon that 25%, which is that lower cap and the difference there. But if you add the 33s together and now you are at 66,000, you're now going to be in a situation where a significant portion of that income as a married couple is going to be subject to that tax on 85% of your Social Security benefits. So on its face, just looking at those numbers and the tax structure that we're working with, you would have been better off, income tax-wise, not to have been married. So that's one thing. It's one thing that Professor Kaplan talks about amongst others. The other one that comes into play that I want to at least mention today is in the area of Medicare and Medicaid. Medicare being the program that you're all familiar with that provides health insurance and prescription medications, doctor's visits, etc. But Medicaid, I tell clients to think of Medicaid as a program that's there to provide for long-term care. You have to go into a nursing home. You can't afford to be paying for in the nursing home, and then you're going to be looking at applying for Medicaid to pay that for you. Well, in Medicaid, there are certain assets that are going to be exempt from having to be spent, but essentially for a single person, okay, you're going to be looking at, you can keep a house, you can keep a car, you can keep a prepaid funeral plan, and then you can keep a couple $1,000s, and then there's a significant portion of your income that's also going to have to be calculated as going into the nursing home. Now, that doesn't change when you're married. Those numbers still stay the same. Essentially, for a married couple, that is, between the two of you, you can have a house. Between the two of you, can have a car. Now, you can each have a prepaid funeral plan, and depending upon the state that you happen to be in, the spouse who doesn't go into the nursing home can keep about $137,000 in additional assets. But the difference is, once you're married, the government now treats you all as one. They don't care who owns the asset. So if between the two of you, you add everything up together, and you have more than those minimums, meaning you have more than a house and a car and two prepaid funeral plans, and more than that $137,000, that money, no matter who owns it, now has to be used to pay for your spouse who's going into that nursing home. So let's use an example. Let's say Bill has $100,000 in assets beyond his exempt resources, so beyond his car, beyond his home, beyond his prepaid funeral plan. And let's say Betty, he's going to marry Betty, and Betty has $600,000 of assets, okay? Now, let's say Bill goes into a nursing home. So Bill's going into a nursing home. He's applying for Medicaid because he's looking and saying, I can't afford to pay this. Well, if it was just Bill that was involved, then Bill's $100,000 would be subject to having to be spent. But if Bill and Betty are married, because the government treats them as one, now Betty's $600,000 also is involved in having to be spent down to pay for Bill's medical care before Medicaid is going to kick in. So basically, what ended up happening in that situation is Betty, who had the greater extent of the assets, by marrying Bill, who had a lower amount of assets, but Bill ends up going to the nursing home. Now Betty has to use her estate to pay for her spouse's care. Now, the other considerations, depending upon the state that you happen to be in, unfortunately, we don't have this in Michigan with appropriate planning, is they might even go after, in that case, Betty's estate after Bill dies to pay themselves back. It's this Medicaid recapture law. I've had other episodes on Medicaid recapture law, so I'm not going to go into that today. The important consideration for today's discussion is this. If Bill and Betty are sitting down and they're looking at their financial situation and they're saying, hey, if we get married, we are now exposing our respective estates to having cover the medical expense for our spouse, because absent that, in the state of Michigan, just because I'm, in the state of Michigan, there's no legal obligation, generally speaking, to pay somebody else's medical expenses. But if you're married and you're applying for Medicaid, now the government's going to make you spend your money. So there's a financial disincentive built into that structure that says, hey, does it really make sense in that case for Betty to say, why am I going to expose my $600,000 to the medical condition for Bill? Or maybe the two of you have even, different scenario and assets, but it's a question that has to be looked at. And that is understanding, I guess not a question, but it's something that you need to understand, is that when you do get married, that can impact dramatically what you're able to save in your estate if one of you has to go into a nursing home. And obviously, that's not something that we generally think about when we're younger. When we're getting married in our 20s and our 30s and our 40s, we're not thinking long-term care. We're not thinking about what's going to happen if one of us goes in a nursing home. But when you look at the probabilities that one or both of you, given longevity, given how long people live today, and what the odds are that one of you, or maybe both of you, but in particular one of you, has to go into a nursing home, which can be pretty substantial depending upon one's other health issues, it lends itself to saying, or to concluding, maybe, for not just maybe, but clearly for financial purposes, you're better off not being married. For income tax purposes, and when we look at the income tax on Social Security, you can be better off not being remarried. So a consideration for you, and again, I'm not one to discourage people from getting married, but there are financial considerations that don't apply when you're younger. When we're younger, there was a benefit to being married financially. When you looked at the income structure, married people paid, generally speaking, a lower tax rate than unmarried people. So there are income tax financial considerations. When we're younger, we're not looking at Medicaid and talking about Medicaid in those circumstances. But now, as older people, those are different considerations. Now, I share with you, I had a client not that long ago who we had this conversation. He came to see me and had this conversation. They were like, oh my God, maybe we shouldn't be getting married, but we've already scheduled the ceremony. We've already got a date. We've already invited friends. We've already got a reception planned. And it's a little bit embarrassing now to say to all of our friends and our family, hey, we've decided not to get married. I mean, the whole stigma, obviously there was years ago a stigma, unfortunately, for people who chose to live together without being married. That stigma has pretty much gone away, but they were concerned in that case about what do we do about the wedding? Do we call it off? Do we tell our friends? And after discussing it some more, one of the things that they thought about, which made sense to me, was, well, what if we still have the ceremony, but we just don't have a marriage certificate? What if we kind of, if you will, pretend that we're getting married? We've already paid for it. We've already got the party planned. Do we really have to tell people that we legally didn't get married? I mean, if that's what they're comfortable with doing. And that in end is what I understood they ended up doing. Their kids, they shared with their kids that they weren't actually getting married, because the kids certainly needed to understand that, because that can have some issues when it comes to how an inheritance would occur, etc., in an estate. But as far as the ceremony, they said the same things. They did all those same things. They just didn't do the marriage license. And because they didn't do the marriage license, they weren't married as far as the state of Michigan was concerned, as far as the federal government concerned. So something to think about if you're looking at getting remarried and you are an older American where Social Security is an issue and potential Medicaid, something to think about. And again, I think I'll post on the office website, or not the office website, but on Facebook and link, and perhaps Twitter. I'll look and see if I can post a link to the article if you're interested in reading more about that. Of course, Amanda and I would be happy to have a conversation with you about these issues that we've talked about today, or if those are not of concerns to you, or even if they are, we'd certainly be interested in having the opportunity to help you protect your loved ones, putting together an estate plan, perhaps amending an estate plan that you currently have, or even assisting you in settling your estate. And as I talked about in last week's episode, we have our virtual office, and that's at doylelawpc.com. And through that virtual office, we are assisting clients throughout the state of Michigan on creating estate plans for them and updating estate plans for them and or settling their estate. So simply go over to Doyle Law PC. You're going to find information there. You also find out at the website if you're interested in scheduling a consultation with you. We can give you a link. We give you a link on the website where you can self-schedule your consultation at a time that's going to be convenient for you. Also, a reminder, current clients, we've already done your estate plan for you. Perhaps you're looking at updating that estate plan, making some amendments to that estate plan. Then take a look on the website at the Update My Plan service. And again, through that Update My Plan service, you'll submit information to us telling us what changes you are looking at making to your estate plan. And then we will get back with you and let you know, do we need to have a consultation? Is it something that we can simply handle without a consultation, and what the cost of doing that would be? And of course, we have our legal store. If you have individual documents that you need, maybe you need an updated certificate of trust, or you're just looking to have a healthcare power of attorney prepared for you, visit our legal store, because through the legal store, you will find that you can likely order that document without the need necessarily to have a consultation, whether you're an existing client or a new client of the office. Well, I think that's going to be it for today's show, though. As always, if you have a comment about the program, perhaps a topic that you'd like to have me discuss, or questions that you'd like to have answered, please send me an email, tom@tuesdaywithtom.com, or you can always mail me a postcard. And we have a new P.O. box if you're going to look at sending us a postcard, and that P.O. box is now P.O. Box 3752, and that's in Grand Rapids, Michigan 49501. Again, P.O. Box 3752, Grand Rapids, Michigan 49501. And as always, we invite you, please follow us on Facebook and Twitter at Tuesday with Tom. And of course, follow the office as well at Doyle Law PC. And please recommend that your clients listen to the podcast and follow us as well on Facebook and Twitter. Of course, the program is available on Apple Podcasts, Spotify, Google Podcasts, iHeartRadio, Spreaker, probably anywhere that you regularly listen to podcasts. You're going to find Tuesday with Tom is available. And if you have a smart speaker, you can always ask your smart speaker to play Tuesday with Tom for you. Well, thank you again for spending some of your time with us today. As always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe now. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.